5, 4, 3, 2, 1. When we turn to the judgment of the tribunal, we find that there is no mention about the question of limitation, even though it stared in the face. It would immediately occur to anyone that since the order of discharge was of 7/10/1986 and the application was filed in 1989, it was clearly barred by limitation unless an application for condoning the delay was made under Section 21(3) of the Administrative Tribunals Act. No such application was in fact made. Even if it was the contention of the employee that he was suffering from schizophrenia, that could have been projected as a ground for condonation of delay under subsection 3 of section 21 of the said statute. Even otherwise, without insisting on the formality of an application under section 21(3), if the tribunal had dealt with the question of limitation in the context of section 21, we may have refrained from interfering with the order of the tribunal under Article 136, but it seems that the tribunal totally overlooked this question, which clearly stared in the face. Even the employee made no effort to explain the delay and seek condonation. We find no valid explanation on record for coming to the conclusion that the case for condonation of delay is made out. In the circumstances, there is no doubt that the application was clearly barred by limitation. It is also difficult to understand how the tribunal could have awarded full back wages even for the period of delay for which the employee was solely responsible. However, since application itself is barred by limitation under section 21 of the Administrative Tribunals Act, it deserves to be dismissed. Learned Advocate General has also placed reliance upon the decision of the Hon'ble Supreme Court in Administrator of Union Territory of Daman and Diu versus R.D. Valand 1995 SUPP 4 SCC 593, wherein it has been held as under. We are of the view that the tribunal was not justified in interfering with the stale claim of the respondent. He was promoted to the post of junior engineer in the year 1978 with effect from 28/9/1971. A cause of action, if any, had arisen to him at that time. He slept over the matter till 1985 when he made representation to the administration. The said representation was rejected on 8/10/1986. Thereafter, for 4 years, the respondent did not approach any court, and finally he filed the present application before the tribunal in March 1989. In the facts and circumstances of this case, the tribunal was not justified in putting the clock back by more than 15 years. The tribunal fell into patent error in brushing aside the question of limitation by observing that the respondent has been making representations from time to time, and as such the limitation would not come in his way. इस वीडियो के डिस्क्रिप्शन बॉक्स में इस पैसेज का टेक्स्ट दिया हुआ है.